Esquire, and O. Folahon. My Lord, we humbly appear for the defendants.
The case is for judgment.
Yes, my Lord.
Okay, this is the judgment of the court. National Judicial Court of Nigeria in the Akure Judicial Division, holding at Akure before His Lordship Honorable Justice K.D. Damulak, dated this 3rd day of November 2021, suit number NICN/AK/30/2021 between Mr. Felix Oladapo Akinusi, Mr. Odutoye Emmanuel Ibitoye, Mr. Precious Chidadi Nwachukwu, Mr. Ayodele Joseph Akinsuyi, Mr. Adeyemi Abiodun Adeseyoju, and Mrs. Adenike Aro. Please, you forgive my pronunciation of the names. And Olusegun Agagu, University of Science and Technology of Tikupa, Vice Chancellor, Governing Council of the said university. Judgment. The claimants commenced this suit by an originating summons filed on the 16th June 2021 against the defendants, seeking the determination of the following questions. 1, whether having regard to the Ondo State University of Science and Technology regulations governing the condition of service of senior staff, April 2021, and Ondo State University of Science and Technology Law 2008, number 2008, which constitute the condition of service of the claimant. The retirement age of the claimant in the employment of the defendant is not 55 years. 2, please, Olatunji, you can off your mic. Olatunji Ato Lagbe, off your mic. Whether in view of the Ondo State University of Science and Technology regulations governing the condition of service of senior staff, April 2021, and Ondo State University of Science and Technology Law 2008, the retirement of claimants by first, second, and third defendants at the age of 60 is not illegal, null, and void. Okay, it's not illegal and a nullity, whereof the claimants sought 7 reliefs, which is basically is declaration that the retirement age is 65 years, and then that the claimants be reinstated, that they be paid their salaries. Those are basically the claim. Then, facts of the case. The grounds of the claimants is that their compulsory retirement from the employment of the first defendant at the age of 60 years when they had not attained the stipulated age of 65 years as provided in their condition of service is wrongful and a nullity. And the case of the claimants is that I've summarized the case of the claimants herein, but the main crux of the complaint is that they were retired after attaining 60 years of age. Meanwhile, that is contrary to the regulations because under Chapter 5, Paragraph 551 of the state regulation, there is a heading known as cessation of appointment and retirement benefit. And by paragraph 514(1) of the said regulation, the age of retirement for all staff of the university is presently 70 years for professional. I doubt if it is professional, it's professorial, but that is what he wrote. Professional cadre and 65 years for academic and non-academic staff. That is the crux of the complaint. The claimant filed a written address in support of their originating summons in line with the rules of this court and formulated a sole issue for the court to determine. And the issue is whether, in view of the affidavit evidence before this honorable court and the exhibits annexed thereto, the claimants are entitled to the relief sought. Learned counsel made submissions in line with the issue as formulated. Counter affidavit of the defendants. The main defense of the defendants, which has been summarized here, but the crux is that contrary to the assertion of the claimants, the retirement age stipulated in the regulation governing the condition of service of senior staff harped upon by the claimants was an incoherent attempt to amend the enabling law of the university, and this was why the regulation was held in abeyance by the management of the first defendant pending legislation by Parliament of Ondo State. And also that a community reading of Regulation 219(1), 5.512, and 5.141 of the regulation reveals that there are contradictory and inconsistent provisions on the matter of age of retirement, that the House of Assembly enacted the long-awaited special provision, and same was passed into law of the Ondo State House of Assembly as assented to by the governor on 31st December 2019. In the written address of counsel to the defendants, he formulated 5 issues. He said whether the express provision of a statute in relation to pre-action notice can be varied unilaterally by the party who has a duty to give such notice. He had raised it in his statement of defense in response to the statement of facts that said they served pre-action notice. Then the defendant said that he's contending that it was incompetent, the pre-action notice. Then whether a subsidiary regulation made by statutory body can amend, alter, modify, or vary the express provisions of a principal law enacted by Parliament on a subject matter, whether enacted law can have retrospective effect or retroactive force, whether estoppel parens judicatam will not bind a party or person being privy and on whose interest and on whose behalf a similar suit was earlier maintained and concluded in judgment. 5, whether the claimant can maintain joint action or suit when their locus standi is contingent on their individual letters of appointment, which have different rights, duties, obligations, and circumstances peculiar to them as separate and individual employees. Learned counsel made submissions in line with the issues court decision. Before going into the merit of this case, it is pertinent to dispose of a crucial preliminary issue raised by the defendant. In paragraph 17 of the statement of defense, stated that the purported letter of pre-action notice referred to in paragraph 18 of the statement of facts is incorrect or improperly formed, and in paragraph 26 of the statement of defense, that the purported pre-action notice issued by the counsel on behalf of the claimants is dated 15th April 2021, but received by the defendant on 20th April 2021, when the notice started to run, and this present suit was filed on 16 June 2021, within 1 month and 28 days as against the stipulated 3 months prescribed by the enabling law of the first defendant. Learned Defendants Counsel contended in issue 1 of his written address in support of the counter affidavit, that is, whether the express provision of a statute in relation to pre-action notice can be varied unilaterally by the party who has a duty to give such notice, that on service of pre-action notice, where pre-action notice is required, the failure to serve the pre-action notice. Okay, that non-service of pre-action notice, where pre-action notice is required, renders a suit incompetent, except where the defendant waives it, and the defendants in this case do not waive the said right. That section 24 of the law establishing the university requires service of 3 months pre-action notice, but in this case, the pre-action notice was dated 15th April 2021 and served on 20th April 2021, while the suit was filed on 16th June 2021, a period of 1 month and 28 days. That this falls short of the requirement of the law and renders the suit incompetent. Learned Counsel relied on Damjor versus AG Benue State, citation supply, State versus Duke, citation supply. The claimants did not file a further affidavit or a reply to this contention. It is either an admission or counsel was satisfied with his pleadings on service of pre-action notice in paragraph 18 of the affidavit in support of the original summons and his exhibit 10 attached. Exhibit 10 attached to the originating summons in compliance with Order 3 Rule 23.1 of the National Industrial Code of Nigeria to Procedure Rules 2017, dated 15th April 2021, is an acknowledgement copy showing it was received by the defendants on 20th April 2021. The pre-action notice is contained in the last but one paragraph of Exhibit 10, and it provides as follows. Take notice that if you fail, refuse, or neglect to accede to our request as contained herein, we have the directive of our clients to commence legal actions against your institution after 30 days, from the date of this action. It is clear that on the face of the originating summons that this suit was filed. It is clear on the face of the originating summons that this suit was filed on 16 June 2021, a period of more than 30 days but less than 3 months after the service of the letter of pre-action notice. Now, Section 24 of Ondo State University of Science and Technology Law, number 2, 2008, provides for 3 months pre-action notice as follows. No suit shall be instituted against the university until the expiration of 3 months next after a written notice have been delivered at the office of the registrar. How can the delivery of a 30 days notice and filing this suit less than 3 months after the service of the said pre-action notice be justified in view of Section 24 of Ondo State University of Science and Technology Law number 2, 2008, is a question which answer the claimant counsel did not make it his duty. In Senator Bello Sarakinyaki and another versus Senator Atiku Abubakar Bagudu and others, 2015, LPLR 25721, Supreme Court, the Apex Court held that a pre-action notice has been held to be a condition for the exercise of the right to bring the action and not abridgment of that right. In Alhaji Abba Sheikh versus Alhaji Kakamalam Yale, 2010, LPLR 3811CA, the Court of Appeal held as follows. Pre-action notice is a procedural step which ought to be taken before an action is filed in court. It is a condition precedent. It does not therefore impede the constitutional right of access to court. In Asset Management Corporation of Nigeria versus Capital Oil and Gas Industries Limited 2019 APR 48065CA, the Court of Appeal for Idigbe held as follows. I must emphasize that AMCON is a creation of statute, and being an institution of corporation, which the statute creating it prescribes a condition precedent before it could be sued. The respondent in this case was under a burden duty to comply with the condition precedent put in place by the said act to clothe her action with validity and competence, and by extension endorse the lower court with virus or jurisdiction to entertain this suit or action. It must be observed that service is this court talking now. It must be observed that service of inadequate pre-action notice is as bad as non-service of pre-action notice. In the circumstance, I find that the pre-action notice served on the defendants falls short of the requirement of Section 24 of Ondo State University of Science and Technology Law number 2, 2008, given the time span between the service of the pre-action notice and the filing of this suit. This failure renders the suit premature, incompetent, and fails to activate the jurisdiction of this court. Accordingly, this suit is hereby struck out. There shall be no need to consider the merit of this case. This is the judgment of the court, and it is entered accordingly. Yes, Kola de Lawal. Kola de Lawal. Steve Adebowale.
My Lord, we are most obliged for the decision just handed down by your Lordship. My Lord, may we ask for each of the defendants a cost of 100,000 naira per defendant, sir.
Okay. Kola de Lawal. Each party to bear its cost. Which one?
Most obliged, my Lord.
AK-59.
You said they will come back.
My Lord.
Yes.
ILO 5. That one is not also.
Who is the other counsel? Bamidele Salawu. Okay. Please, appearance. Your mic is on mute. AK-59 is Alhaji Ganiu Olasun Kanmi Salawu. And that is Babalola with Suleiman and Bamidele Salawu. Okay. Yes. AK-59 2018. Alhaji Ganiu Olasun Kanmi Salawu and 3 others, and yes, and 3 others. Then Governor of Osun State, Attorney General Osun State people.
My Lord, sir.
Yes.
My Lord, sir.
Yes.
Yes, sir. Salawu is on the line, sir.
Appearance, please.
May my noble lobby, please, sir.
Yes.
Bamidele Salawu. Chief State Counsel, my lord. Appearing for the defendants. Grateful, sir.
Did you see the claimants counsel online?
And I have not seen him this morning online, sir.
Okay. This is the judgment of the court. This is the judgment. I thought usually counsel should stay as a couple so that we know we are together.
As couple, sir. As couple, sir. As
So
couple,
you
sir.
are listening to me. I said this is the judgment and you kept quiet.
I'm very sorry, sir. Yes, sir.
You need to show that we are together now. Okay. In
Grateful,
the
sir.
National Industrial Court of Nigeria and the Judicial Division of the Akure before His Lordship Honorable Justice Keji Damlak, dated this 3rd day of November 2021. Suit number NICN/AK/59/2018 between Alhaji Gani Olasun Kanmi Salahu and 3 others for themselves and on behalf of other members of Nigeria Union of Pensioners, NUP, and Governor of Osun State, Attorney General of Osun State as defendants. The claimants commenced this action by a general form of complaint filed on 16 October 2018 seeking the following relief: a declaration that payment of pension and gratuity is a constitutional right of claimants, a declaration that the claimants are entitled to full payment of their pension without alteration to their disadvantages as provided for in Section 210 of the 1999 Constitution. Let me add, as amended. He didn't add it.
As couple, sir.
A declaration that the claimants are entitled to a periodic, that's 5 years upward review of their pension every 5 years. So that is his own grammar. A declaration that failure and or refusal of the defendants to implement circulars is arbitrary and unconstitutional. A declaration that alteration in the monthly pension of the claimants to their disadvantage by the defendants is arbitrary and unconstitutional. A declaration that the payment of reduced pension from September 2015 to June 2018 to the claimants is against the provisions of Section 210 of the 1999 Constitution of the Republic of Nigeria as amended. This one, he put the amended here. A declaration that failure of defendants to pay some of the claimants their monthly pension for November/December 2012 since then is arbitrary and unconstitutional. A declaration that some of the claimants who are contributory pensioners are entitled to prompt payment of their contributory pension. A declaration an order of court mandating or directing the defendants an order of court mandating or directing the defendants to implement circulars on overall review of pension as issued and as they affect the claimants. An order of this court directing defendants to pay to the claimants the balance of their monthly pension from September 2015 to June 2018. An order of this court directing the defendants to pay the claimants all the balance of their gratuities and those that are yet to be paid up to date. An order of perpetual injunction restraining the defendants, their servants, privies, or assigns from any further implementation of any modulated monthly pension and or reduction or deduction of their monthly pension. And 13, an order of court directing the defendants to immediately pay to the claimants their contributory pension since 2013. The defendants filed a memorandum of conditional appearance on the 16th January 2019 and their statement of defense, and later filed an amended statement of defense consequent upon the order of this honorable court dated 24 June 2020. Facts of the case: the grounds upon which the claimant's case is predicated is the willful refusal of defendants to pay the claimant's pension and gratuity as at when due, payment of modulated pension, failure to implement the upward review in pension as stipulated in 1999 Constitution as amended, and non-implementation of harmonization of pensions. The defendants, on the other hand, maintain that it has always discharged its duties of paying salaries, pension, and other civil responsibilities in the state without fail from inception until the recent experience paucity of funds, which started in 2014 as a result of the global recession that occasioned dwindled federal government statutory allocation to the state. Case of the claimants, the summary is set out here, but the crux is as already read. We will see more details in the course of the judgment. But all the set out summary here is nothing but the complaints, which is the 6 complaints that I have already read. Case of the defendants is already as also read that they have always paid, although they have also admitted that there are some that they are yet to pay, but there is approval already and so forth. Defendant's final written address. The defendant formulated 2 issues, and that is whether considering the prevailing financial situation, which drastically affected the governance of Osun State in year 2014, the defendants altered the payment of the claimant's monthly pensions paid on an agreed percentage with the months of September 2015 to June 2018 to pensioners' disadvantages. 2, whether considering totality of the pleadings filed, the defendants refused to and have not implemented the approved circulars on upward review of pensions as it relates to the claimants. Learned Counsel made submissions in line with these issues that he has formulated. The summaries are herein contained. Claimant's Counsel final written addresses. The Claimant Counsel formulated 5 issues: whether the defendants altered the payment of claimant's monthly pension within the months of September 2015 to June 2018, and the claimant's pensioners to the claimant's pensioners disadvantage. 2, whether the claimants are entitled to upward review of pension as when due, and whether the court should direct the defendants to pay balance of all upward review, especially 142%, 21%, and 33%, and such any subsequent reviews. 3, whether the contributory pensioners are entitled to their pension as and whether the claimant's gratuity was paid as and when due. 4, whether the claimant is bound by the various MOUs, exhibits LBK 1 to 4, and or whether paucity of funds raised by the defendants is a sufficient reason for the defendant to alter and or withhold part of the claimant's pension and or gratuity and or pay a modulated pension to the claimants to override the constitutional provision mandating the defendants to pay the full pension and gratuity to the claimants as at when due, so long an issue. Whether or not the claimants are entitled to any of all relief sought, and if yes, whether the court should grant the relief sought. Learned Counsel made submissions in line with the issues as formulated. I am summarizing like this because we have a long judgment. Court's decision. Having thoroughly considered the pleadings, the first witness statements and cross-examinations, documents and written addresses, it is clear that the issues calling for determination in this case are numerous, and the issues for determination formulated by the claimant's counsel will better reflect the contentions in the case. There are 6 contentions in this case, and they will be produced and considered at the appropriate time. A single issue can be formulated from these 6 contentions as whether the claimant have proven their claims. Before delving into the issues, some preliminary issues call for attention. They are determination of exhibits objected to and marked tendered, whether some paragraphs of the claimant's pleadings are to be deemed abandoned, and whether the claimants herein have the consent of the over 12,000 members of the Nigerian Union of Pensioners in Osun State to institute this action on their behalf. Another preliminary issue is raised by the claimants in their reply to the effect that most of the documents attached to the amended statement of defense were largely prepared in anticipation of this suit. Determination of exhibits objected to and marked as tendered. At the hearing of the suit, the claimant tendered a bank statement of the second claimant, NUP minutes of meeting and circulars in evidence, and the defense counsel objected to them, whereupon these documents were marked as Exhibit OHA 1, 2, and 5 tendered and ruling reserved till judgment. It is the submission of counsel that Exhibits OHA 1, 2, and 5, which were wrongly tendered by the claimant as objected by the defendant, should be expunged or no probative value should be attached to them. He cited the case of Flash Fixed Odds Limited versus Akatuba 2001, Federation Report per 76, page 709, ruling on Exhibit OHA 1 tender. The objection of the defense counsel to the bank statement, Exhibit OHA 1 tender. There is another court going down there, and my ears are so good this morning because I took very good breakfast. So every system of mine is functioning very well. I can hear the side discussion from there. So if you cannot lower the discussion than that volume, please switch off. Thank you. Exhibit OHA1 tender is simply on the ground. Okay. The objection of the defense counsel to the bank statement, Exhibit OHA1 tender. Infinix Hotline Play, please switch off your mic. Switch off your mic, please. Infinix Hotline Play. Switch off your mic. The objection of the defense counsel to the bank statement, Exhibit OHA1 tender, is simply on the ground that the one front-loaded is not certified. There is no complaint as to whether the CTC tendered in evidence is a different copy from the one from that which was front-loaded. It is the view of this court that when a party front-loads a document, there is nothing stopping him from getting a CTC of the said document for the purpose of tendering same in court, as a tendered document can even be withdrawn, certified, and retendered in evidence. Exhibit OHA1 tendered is accordingly admitted in evidence and marked as Exhibit OHA1. That is, we have removed the tender now. Ruling on Exhibit OHA2 tendered. This document is said to be minutes of meeting of the NUT Osun State held on 22nd May 2018. The objection of the defendant's counsel to the admissibility of this document is that the document does not bear the name of the witness as attending that meeting. Counsel has not cited what law prohibits CW1, a member of the union, from tendering the document until he shows that he attended the state meeting. Counsel had opportunity to elaborate on his objection in the final written address, but did not advance any legal argument on this point. This objection is baseless in law and is hereby overruled and dismissed. The minutes
call,
of
please.
meeting of the NUT Osun State held on 22nd May 2018 is admitted in evidence and marked as Exhibit OHA2. Ruling on Exhibit OHA5 tender. This document is a circular dated 5th August 2010 from the National Salaries, Incomes and Wages Commission. The objection of the Defense Counsel to the admissibility of this document is that it is irrelevant to the case of the claimants. It relates to federal workers. This document was pleaded and it is a CTC. It is admissible in evidence. The weight to be attached to it is another issue, depending on what use the claimant's counsel put it to in the final written address. Accordingly, the objection is overruled and the document is admitted in evidence and marked as Exhibit OHA5. Ruling on whether paragraphs 7 to 24 of the claimant's complaint and paragraphs 1 to 25 of the consequential amended reply should be deemed abandoned. Learned counsel for the defendants argues that from paragraph 7 to 24 of the claimant's complaint and paragraph 1 to 25 of the consequential amended reply to the defendant's statement of defense is deemed abandoned as there is no evidence laid to support them by the claimant. Paragraph 7 to 24 of the claimant's complaint. I have carefully read paragraph 7 to 24 of the statement of facts as well as the entire witness statement on oath of PW1, and I find that paragraph 10 to 30 of the said witness statement is a near reproduction of the said paragraph 7 to 24 of the statement of facts. I find that paragraph 7 to 24 of the statement of facts are covered by paragraph 10 to 30 of the witness statement on oath of PW1. The paragraphs cannot be deemed as abandoned. The objection on this basis fails and is dismissed. Paragraphs 1 to 25 of the consequential amended reply. For a start, the consequential amended reply has only 18 paragraphs and not 25 paragraphs. I have read the 18 paragraphs reply and the 25 paragraph witness statement on oath accompanying them, and I find that paragraphs 2 to 22 of the witness statement on oath of PW1 is a near reproduction of paragraphs 2 to 17 of the reply. The paragraphs cannot be deemed as abandoned. The objection on this basis fails and is dismissed. Documents allegedly prepared in anticipation of this suit. Another preliminary issue raised by the claimants in their reply is to the effect that most of the documents attached to the amended statement of defense were largely prepared in anticipation of this suit. There are no further particulars apart from the ipso dixit of the PW1. At the trial, learned claimants counsel did not object to any of the 11 documents tendered in evidence by the defendants. It should be taken that none of those documents allegedly prepared in anticipation of this suit was eventually tendered in evidence. I so find. Whether the claimants herein have the consent of the over 12,000 members of the Nigeria Union of Pensioners in Osun State to institute this action on their behalf. So many preliminary issues. But I think this is the last preliminary issue, and it's rather a long one too. The claimants avert in paragraphs 1 and 2 of the statement of facts as follows. 1. The claimants are chairman and members respectively of the Nigeria Union of Pensioners, NUP, Osun State Chapter. 2. The claimants bring this suit for themselves and on behalf of other members of the NUP, Osun State Chapter. The defendants in paragraph 1 of their statement of defense challenge the claimants as follows. The claimants are just few aggrieved retirees out of over 12,000 civil servants who had retired from the public service in the state, and hereby put them to the strictest proof of having the consent and or authority of the entire pensioners to institute this suit in court. The claimants replied in paragraph 2 of their reply as follows. In answer to paragraph 1 of the statement of defense, the claimants are not a few aggrieved retirees, but are the accredited representatives of the vast majority of retirees who are being treated as third-class citizens by the defendants. This suit is brought in representative capacity on the authority of their various groups in the union to file this suit. Copies of the minutes of the claimants union is also pleaded. The said copies of the minutes of the claimants union is the minutes of meeting of the NUT Osun State held on 22nd May 2018, which has been admitted in evidence and marked as Exhibit OHA2. First of all, it is to be noted that the Nigerian Union of Pensioners is a registered trade union listed as number 24 in the third schedule to the Trade Union Act Captive 14, and so is entitled to sue and be sued in its registered name. But this action is brought in a representative capacity, and so the rules as to representative actions must apply. By Order 13, Rule 11.1 of the rules of this court, where there are numerous persons having the same interest in one suit, one or more of such persons may sue or be sued on behalf of or for the benefit of all persons so interested. In Ovenseri and Osagede, 1998, 11 Agreement Report, Part 5721, and also 1998, 7 ST, Part 235. It is also to be found in 1998 LPLR 2834 SC. The Supreme Court held per Idigbe SC. The Supreme Court per Idigbe SC held as follows. It was long settled that the representative action is only permissible if more persons than one have a common interest in a suit, and the persons interested in suing have given the authority to the named plaintiff or plaintiffs to sue on their behalf. In Exhibit OHA2, the minutes of meeting of the NUT Osun State held on 22nd May 2018, which according to the claimants contains the authority of the various groups in the union to file this suit. I find on the first page of that document at paragraphs 04 and 05 that an action committee was set up, and a subcommittee of the said action committee is the legal subcommittee saddled with the task of collecting all the pensioners' grievances with a view to seeking legal redress in the appropriate law court. Then they put there in bracket the National Industrial Arbitration Court. And on the second page, at paragraph 05.2I and II, titled resolved as follows. 1, that the subcommittees be and were approved as constituted. 2, that legal action be instituted against the Osun State government, outstanding pension benefits of the Osun State pensioners. Although the names of the claimants were not specifically mentioned in the above minutes, there is ample evidence in the minutes that a committee was set up with a view to seeking legal redress in the appropriate law court, and there was a resolution that legal action be instituted against the Osun State government, outstanding pension benefits of the Osun State pensioners. You will see that your brain is telling you a word is missing, a word or two are missing, but it is how it was in the minute. Instead of saying for the, they didn't add that for the, or they omitted for the, but at least the sense is understood. In the circumstance, the authority of the claimants can only be denied by the other members of the NUT, Osun State chapter. This is even so as the court takes cognizance of the fact that several of the pensioners used to troop to court in buses on each day the case came up, in spite of repeated appeal from the court for them to stay at home to avoid accidents and coronavirus. I don't know, one of you must have been here one of those days when they came and pulled this court here, and I was pleading with them, don't be traveling with, that's what I'm referring to here. In the circumstance of this case and in the absence of denial of the claimant's authority by members of the NUP and Osun State chapter, the court hereby finds that the claimants have the authority of the members of their union to institute this action in a representative capacity. It is pertinent to observe that the claimant counsel who tendered Exhibit OHA2 in proof of the fact that the claimants had the authority of their union to sue in a representative capacity did not in his final written address draw the attention of the court to the said authority in the said document. Counsel was simply satisfied with the fact of having tendered the 3-page document to the court, as if the document contained only authority to sue. He left it for the court to find out. This kind of practice, besides failing to aid the court, is capable of having avoidable huge consequences on the case presented by counsel. Counsel could have done better. I always say this. You see, a court has many other files and many other cases to attend to. So if a judge has many judgments to attend to at a time, and then you are bringing documents, you have tendered it in evidence, quite okay. You have simply said it contains the authority, that's all. Now it's a 3-page document. At least you can say paragraph this on page this, if you don't even cut it out. But just to leave it like that, you may not like the consequences. For instance, in this one now, if I say, well, you did not point it out, and I rule against you, when you go to Court of Appeal, it is at that time now you will say, look, my lord, at page this paragraph, this, it is there. You are also being unfair to the lower court because you didn't do that work. You are being paid. What is your own work that you will leave it for the court to go and find out? Please, let's try to help. And then some of you, what you do is, during cross-examination is when you try to confront a witness with it as if he can interpret it. And then after all the confrontation of the witness with those things, I don't remember anyone that I saw in the written address. Okay, this was what happened. See what witness said about this paragraph of this document. I've not seen it. Anyway, that is it for now. Merit of the case. As earlier pointed out, the case of the claimants can be summarized into 6 complaints, and the issue for determination is whether the claimants have proven their claims. It also appears to me that the evidence of the witnesses in chief and their cross-examination provided sufficient materials for the determination of the issue in this case. The learned counsels for both parties have properly made their written submissions in line with their respective clients' cases. The court shall now proceed to determine the issue for considering the issue by considering the evidence of the witnesses in chief and under cross-examination and the documents on each of the 6 complaints, which are as follows. These are the complaints, the 6 complaints that will be used to determine the issue. 1, payment of modulated salary and pension, whereby pension was arbitrarily altered to our disadvantage from September 2015 till June 2018. 2, the first defendant has failed to make its contribution under the pensions contributory scheme, and the pensioners now cannot get their pension, which has led to avoidable sufferings and death at times. of many of us pensioners. The defendants only paid 100,000 to pensioners whose gratuities run into millions of naira. That's three. Four, the defendants have also failed to pay some of us the outstanding gratuities for 2008 to 2012, as well as federal gratuities from 2000 to 2001 pensioners. Five, the first defendant has also failed to implement all circulars on upward review of pensions, excuse me, as it relates to us, including the payment of the balance of arrears of 142% pension, 42% pension increase, 21% pension increase, 19% pension increase, outstanding gratuities from 2008 to 2012 pensioners, federal gratuities from, no, this one is a repetition. Implementation of 33% increase. Six, in November and December 2012, the monthly pension of some of us were deliberately withheld or diverted for no just cause at all. Consideration of the complaints. One, payment of modulated salary and pension, whereby pension was arbitrarily altered to our disadvantage from September 2015 till June 2018. The response of the defendants to this is the payment of pension in the state was never arbitrarily altered to the disadvantages of the claimants, but on modalities stipulated in line with the MOU, a collective agreement signed by the labor union NUP inclusive, with the government owing to the financial predicaments of the state. The payment of the alleged modulated pension was in line with the MOU of the Joint Negotiating Council's JNC committee, as well as the agreed modalities on apportioning of the available revenue and other critical expenditures. The further explanation to the above is as follows. The defendants and all the entire representative of the public workers, that is the labor unions and other affiliates, including the National Union of Pensioners, held several meetings on the way forward. The meeting crystallized into a collective agreement in several memorandum of understanding jointly signed by the state government with critical and relevant representatives of the labor union in the state to allow for the smooth running of the state. The MOU approved that the active workers on grade levels 1 to 7 and retirees on monthly pensions of 30,000 and below are to be paid 100%, while workers on level 8 and above, together with pensioners or retirees earning above 30,000, are to be paid 75% of their salary and pensions respectively. The claimants in their reply assert as follows: that the purported signatories to the MOU are unknown to the claimants, and the signatories never had the mandates of authority of the claimants to act, that the defendants merely picked members that were loyal to them to sign the MOU, which is therefore not binding on the claimants. The relevant MOUs are: one, Exhibit LBK1 executed on 30 December 2017. This document was not executed by the NUP. Exhibit LBK2 executed on 16 September 2015, which was signed by one Olatunde Oguni for the NUP as the NUP representative. The averment that the defendants merely picked members that were loyal to them to sign the MOU without more is not enough for the court to find that the document is not binding on the claimants. Three, Exhibit LBK3 executed on 29th July 2015. This document was not executed by the NUP. 4. Exhibit LBK4 executed on 13th July 2015. This document was not executed by the NUP. The only document executed by the claimants is Exhibit LBK2, and it does not contain anything about modulated pension. The only reference to pension in the state document is item IV, that is 4, and V, that's 5, on the first page as follows. IV, the state pensioners be paid balance of December 2014 as well as January, February, and March 2015 pensions, while their counterparts in the local governments and primary schools be paid up to June 2015. V, that payment of II and IV above be effected immediately. That's what is in that document. The MOU that carries the agreement of modulated pensions is Exhibit LBK1 in paragraph B on the first page as follows. B, monthly payment of pensions. The state government has further approved henceforth 100% payment of monthly pensions for retirees earning 30,000 naira and below, while other retirees not in the said category shall, however, be paid 75% of their pension. The NUP is not a signatory to the said MOU. This much was also confirmed by DW1 under cross-examination, and so the NUP is not bound by the said MOU. The said modulated pension is not denied by the defendants, and the claimants contend that they have not been paid the balance of the said modulated pensions from September 2015 till June 2018. This has also been admitted by the defendants. The DW1 admitted under cross-examination as follows. As at October 2018, the defendants were owing the claimants part of the modulated pension, that is balance of pension. We have not paid everybody the balance of the modulated pension. Those that have been paid, we did not pay them the full balance. I find, therefore, that whether or not the claimants were signatories to the MOU on modulated pensions, Exhibit LBK1, and I put in bracket, it has been established that they were not signatory to it, bracket closed. The claimants are being owed balance of modulated pension from September 2015 to June 2018 are entitled to be paid. I so order.
As the court pleases.
2, the first defendant has failed to make its contribution under the pensions contributory scheme, and the pensioners now cannot get their pension, which has led to avoidable sufferings and death at times of many of us pensioners. The defense is as follows: that the defendants have never been slack in discharging their responsibilities. This is evidenced in bond certificates and clearance letter issued to those in the contributory pension scheme, CPS, in order to ensure that their various PFA, that's pension fund administrators, paid them their retirement benefits. However, under cross-examination, DW2 testified as follows, and I quote him: there is no time for payment of CPF after payment of salaries. There are still some pension deductions that the government is yet to remit to the PFA. The issuance of the CPS bond depends on when the retiree finishes processing his file. After issuance of the bond, the pensioner have no business with the government, but with his PFA. The government is not in the position to know when PFA has paid. From the admission that there are still some pension deductions that the government is yet to remit to the PFA, it follows that the issuance of bond certificates and clearance letters issued to those in the contributory pension scheme, CPS, is of no moment when the said pension contribution has not been remitted to the PFA. It holds true then that the claimants so affected cannot access the said contributory pension funds. I find and hold that this allegation of non-remittance is proven, the defendants ought to, and I hereby order to ensure such remittance. 3. The defendants only paid 100,000 naira to pensioners whose gratuities run into millions of naira. The response of the defendants to this complaint is as follows. The payment of 100,000 naira, which was later graduated to 200,000 naira to all the retirees, was at their instance after due consultation with the NUP to help ailing pensioners cater for themselves, as such, devoid of any political coloration. This response is an admission, or rather confirmation, of the allegation. The confirmation was made even stronger when DW2 testified under cross-examination as follows, and I quote him: "We have paid the claimants only 300,000 as gratuity since 2014. Presently, we are owing the claimants 200,000 across board to make it 500,000. We have paid some of the claimants 200,000, but some are yet to be paid. It is an ongoing process. The money is released monthly. Some of the claimants are entitled to about 3 to 5 million as gratuity. I find that the claimants have established the fact that the defendants only paid less than 500,000 to pensioners whose gratuities run into millions of naira. The claimants are entitled to be paid the balance of their gratuities, and I so order." All machine for me. All machine for me. It remains the other pages of this judgment. Or bring my laptop. Let me read it from the laptop. Sorry, I think in the course of the printing, the remaining pages are left out. How did you not notice this? I'm sorry about this. Okay, fourth complaint. The defendants have also failed to pay some of us the outstanding gratuities for 2008 to 2012, as well as federal gratuities from 2000 to 2001 pensioners. The response of the defendants is as follows. Also, the gratuity and pension were fully paid as at when due to the pensioners who have duly processed their retirement papers to the Bureau of Pension in the state before and after the period of paucity of funds in the state. The full gratuity, which included a federal share of gratuity, had already been paid to all the pensioners who had processed their retirement benefit to the Bureau of Pension. This response, together with the response of DW2 under cross-examination, that we have paid the claimants only 300,000 naira as gratuity since 2014. And that some of the claimants are entitled to about 3 to 5 million as gratuity. The implication is that some pensioners are yet to be paid their gratuity, either because they are yet to duly process their retirement papers at the Bureau of Pension in the state, or because they have only been paid 300,000 as gratuity so far out of 3 to 5 million. This court finds that the claimants have approved this claim. 5. The first defendant has also failed to implement all circulars on upward review of pension as it relates to us, including the payment of the balance of arrears of 142% pension increase, 21% pension increase, 19% pension increase, implementation of the 33% pension increase. The response of the defendants to this is all circulars on the upward review of pensions as they relate to the claimants were duly and regularly implemented as at when due in line with the extant law of the land and in conformity with the stipulations in the collective agreement executed by the labor unions in the state. The Bureau regularly implements federal government circulars on upward review of pensions whenever approved by the state government after it shall have taken cognizance of extant laws of land permitting implementation. And the remaining part, I highlighted it. It reads, it is only the circular on 33% of the pension that is yet to be implemented due to the paucity of funds in the state, that the circular of 142% has been duly approved and about to be cashed back from the meager resources available to the state. From this response, there is admission that the 33% and 142% pension increase are yet to be implemented, meaning that only the 19 and 21% pension increase are said to have been implemented. The claimants pleaded in the negative, that is concerning the 19 and 21%. The claimants pleaded in the negative, non-implementation. The defendants pleaded the positive, full implementation. By reason of section 131 and 132 of the Evidence Act, the burden of proof of implementation of the 19% and 21% increase is on the defendants. See ANIA versus ANIA 2014 LPAR 22479CA, where the court held. It is settled that the burden of proof rests on the party who asserts the positive and not on one who affirms the negative. The maxim is he who asserts must prove. See section 135 and 136 of the Evidence Act 1990, now 133 and 134 of the Evidence Act 2021. See also Oniki versus Oniki 2008 APLR, Wondo versus Bello 2016 APLR, and Ojo versus Kamalu 2015. All citation fully supplied. This burden of proof is not discharged by merely stating that we have fully implemented SEM. Documents are required to back it up. This has not been done. A defense fails and the whole allegation stands as proven. I so hold. Complaint number 6, which is the last complaint. In November and December 2012, the monthly pension of some of us were deliberately withheld or diverted for no just cause at all. The response of the defendants to this claim is, we deny that the November to December 2012 monthly pension of the claimants were deliberately withheld. The fee omitted was due to the delay caused as a result of the migration of pension data from analog to digital system documentation that was then carried out in the state. The migration exercise has now been concluded and the affected persons now duly paid their entitlement. I find this defense to be true based on the admission of the CW1 under cross-examination that before the case, the state government was paying us regularly until 2015. So if they were paying regularly until 2015, you cannot come and be talking about November, December 2012. This allegation is contradicted under cross-examination and in support of the statement of defense. It stands rebutted. The allegation fails and is dismissed. On the whole, the case of the claimant succeeds. Court order. For the avoidance of doubt, it is hereby declared and ordered as follows. 1. A declaration that payment of pension and gratuity is a constitutional right of claimants. 2. A declaration that the claimants are entitled to full payment of their pension without alteration to their disadvantages as provided for in Section 210 of the 1999 Constitution as amended. This one is my order. I can act as amended now. A declaration that the claimants are entitled to a periodic upward review of their pension. A declaration that failure and or refusal of defendants to implement circulars relating to claimants' pensions is arbitrary and wrongful. Five, a declaration that alteration in the monthly pension of the claimants to their disadvantage by defendants is arbitrary and unconstitutional. A declaration that payment of reduced pension from September 2015 to June 2018 to the claimants without their consent is against the provisions of Section 2010 of the 1999 Constitution as amended. 7, a declaration that some of the claimants who are contributory pensioners are entitled to prompt payment of their contributory pension. 8, it is hereby ordered that the defendants implement circulars on upward review of pension as issued and as they affect the claimants. 9, the defendants are hereby ordered to pay to the claimants the balance of their monthly pension from September 2015 to June 2018. The defendants are hereby ordered to pay to the claimants the balance of their monthly pension from September 2018. 10, the defendants are hereby ordered to pay the claimants all the balance of their gratuities and those that are yet to be paid up to date. 11, an order of perpetual injunction restrains the defendants, their servants, privies, or assigns from any further implementation of any modulated monthly pension and or deduction of the claimant's monthly pension. 12, the defendants are hereby ordered to immediately remit to the claimant's PFA their contributory pension funds. This is the judgment of the court and it is entered accordingly. Counsel. Counsel. Okay. Judgment is read and entered. Okay, it remains which one? ILO 5. Fidelis Fadu Bagbe and 4 others versus Executive Governor of Kwara State.
Yes, my lord, we are online.
Okay,
My Lord, we are here too.
that's good. Give me the camera. Appearance?
With profound respect to my noble lord,
Yes.
A.M. Saliman is my name. I most humbly announce my appearance for the claimants.
Yes, who is appearing for the defendants?
With profound humility, my Lord, I am A.M. Bello, sir.
A.M. Saliman, A.M. Bello.
A.M. Bello, sir. I appear humbly. with my
Battle of
learned-
the A.M. A.M. Bello.
I appear with R.K. Abdul Qadri.
No, DCL, Kwara State.
Very well, sir. I'm grateful. Yes, sir.
You are with
R.K. Abdul Qadri, Senior State Council, sir. And B.O. Banigbe. B.O.
Idigbe.
Banigbe, Senior State Council, sir. My Lord, we appear for the defendants.
Okay, the case is for judgment. And the
As the
judgment
accomplices.
is ready.
As the accomplices.
Okay, this is the judgment of the court.
As the accomplices.
We are going to summarize a lot of even what I have summarized here. I will summarize it.
As the accomplices.
Yes. So judgment, we'll skip the heading.
As the accomplices.
Judgment. The claimants commenced this suit by general form of complaint dated 7 October 2020. That is serious.
As the accomplices.
I can see 2 days here. And I even proofread this thing. I can see did you amend? So is your complaint 7 October or 12 October? But was it filed 12 October? Okay. Dated 7th October 2020 and filed 12 October 2020. The claimants claim against the defendants jointly and severally as follows. These numerous prayers is going to be one of the things that we are going to summarize because there are 22 reliefs. So if I am to read the 22 reliefs, I think you will be tired even just listening. But the reliefs have to do with asking the court to set aside the queries issued on the claimants, setting aside their termination, and then monetary claims that follows. That's a summary of the relief. First, the defendants filed a memorandum of conditional appearance and a joint statement of defense accompanied by all necessary processes on the 30th December 2020 and improperly filed and served on 19 March 2021. Facts of the case. Claimants were Claimants were employed into the service of the 4th defendant and they rose to be heads of their respective units. The 5th defendant issued them with queries accusing them of submitting inconsistent and unfair reporting of staff performance. The first claimant was, however, on leave when these queries were issued, but the second to fifth claimants responded to the said queries. They got an invitation to appear before the disciplinary committee, which they did. The first claimant was not invited. The second to fifth claimants were not confronted with any document at the disciplinary committee nor any evidence called against them. The defendants, on the other hand, contends that the termination of the claimants' appointments were based on poor performance and inconsistency in the report of performance of staff under them from the months of July to September 2017. They were paid their 1 month salary in lieu of notice of termination of their respective appointments. Case of the claimants, there shall be no need to set out the case again. Any other details about the facts, we'll meet them in the course of the judgment.
As a couple.
Case of the defendants, we shall not set it out. It is set out here, but I will not read it again because it is as already captured in the summary. Then any further details, we will meet it in the course of the judgment. The defendants' counsel formulated 4 issues as follows: whether there is a reasonable cause of action against the first, second, and third defendants in this case, whether by the letter of appointment of the claimants, the fourth defendant has power to terminate the appointment of the claimants at any time. 3, whether having regard to the facts, circumstance, and evidence, both oral and documentary, led by the parties in this case, the claimants were not given fair hearing before their employments were terminated. 4, whether the claimants are entitled to the relief sought in this case. Learned counsel made submissions appropriately according to the issues formulated. Claimants counsel also formulated 2 issues. 1, whether there is no cause of action against the first to third defendants. 2, whether from the facts, circumstance, and evidence laid before this honorable court, the termination of the employment of the claimants is not unfair, unjust, illegal, ultra-various, and against the principle of natural justice and fair hearing. Learned counsel also make appropriate submissions in line with the issue determined. There is reply on point of law also. Court's decision. Having read the entire pleadings, evidence, and final written addresses of counsel, it is clear that the issue for determination and the story giving rise to the issue is narrow. The claimants are claiming 22 reliefs, and their statement of facts is 94 paragraphs, and they tendered 45 documents in evidence. The defendant filed an 82-paragraph statement of defense. However, the entire story can be summarized as follows. I take time to summarize the story once again because it's a huge something. I've not even told you how many paragraphs they reply. So it's a huge something, but I have taken my time to try to capture the kernel of the matter. The summary of the matter is the claimants were employed as staff of the fourth defendant and rose to be managers and heads of their unit. They were accused of inconsistency and unfair reporting of staff performance under them. They were queried, appeared before a panel of investigation for the said accusation. During the said period, the first claimant was on leave and could not be served. Thereafter, they were terminated for services no longer required on the ground of poor performance. Given the above facts, besides the issue of whether there is disclosed a cause of action against the first to third defendants, the issue for determination as formulated by both counsel can be compressed as whether the claimant's appointments were lawfully terminated. Before determining the issue, it is pertinent to start with an issue which is more of preliminary, and that is the question of whether the claimant discloses any reasonable cause of action against the first to third defendants raised by the counsel to the defendants. This issue raises 2 questions, namely 1, whether or not there is a cause of action against the first to third defendants. Two, are the first to third defendants necessary parties to this suit? To answer the first question, one only needs to look at the statement of facts to see the complaint against the first to third defendants. The court finds no iota of complaint against the first to third defendants in the statement of facts, neither did the claimant counsel point them out. This again is part of my trouble. Somebody is saying you did not disclose cause of action against him. You people are writing addresses. You will just say cause of action disclosed. Hi, this is worrisome. Show me this is the cause of action against this thing. Look at our paragraph, this to this. Simple as that. Somebody will not say it. So I should go and look for it for you. Again, leaving the work for the court. Meanwhile, your client pays you. To answer the second question, one will have to ask, can this suit be conveniently determined in the absence of the first to third defendants? Can any possible judgment obtained by the claimants in this case be executed without the first to third defendants? If the answers to the above questions are in the affirmative, then the first to third defendants are not necessary parties and their names ought to be struck out. Without much ado, I answer the questions in the affirmative. This issue is resolved in favor of the defendants. This court accordingly strikes out the names of the first to third defendants from the suit. Whether the claimant's appointment were lawfully terminated, that's the merit now. In determining this issue, it will be proper to first determine the status of the claimant's employment. This is necessary in order to be able to determine whether the claimant's employment can be terminated for services not required. Whether the employment of the claimants were statutorily protected. The law is now settled that it is not every employment with a statutory body that enjoys statutory protection. It is not in dispute that the claimants were employees of the fourth defendant. The fourth and sixth defendants are creations of the Kwara State House of Assembly, Kwara State Revenue Administrative Law 2015, Kwara State Revenue Administration Law 2015. A reproduction of some provisions of the said law is relevant here in determining the employment status of the claimants. Section 10(1) provides, the board may appoint such other staff to be employees of the service in positions created by the board and on such terms and conditions as shall be laid down by the board subject to the provisions of this law or any other enactment. 11(1). Subject to the provisions of this law, the board may make staff regulations relating generally to the condition of service of the staff, and in particular, such regulations may provide for A, the appointment, promotion, termination, dismissal, and disciplinary control of staff or employees of the Internal Revenue Service. B, appeals by staff or employees against dismissal or other disciplinary measures. And until such regulations are made, any instrument relating to condition of service in the public service of the state shall be applicable, with such modifications as may be necessary to the employees of the service. 11(2). The staff regulations made under subsection 1 of this section shall not have effect until approved by the governor, and when so approved, they shall be published in the State Gazette. 11(4). Employment in the Internal Revenue Service shall be subject to the provisions of the pension legislation for the time being in force in Kwara State, and accordingly, officers and employees of the service shall be entitled to pensions and other retirement benefits as are prescribed under the relevant law. It is the firm view of this court that any instrument relating to condition of service in the public service of the state must be purposefully interpreted to mean a reference to include a reference to the public service rules of Kwara State and not just any instrument at large. In any event, the public service rules of Kwara State cannot be excluded in any meaningful interpretation of any instrument relating to condition of service in the public service of the state in the Kwara State Revenue Administration Law 2015. From the above reproduced provisions, we see the board empowered to employ staff and create positions. The employment subject to public service rules of the state. The board may choose to make its own rules subject to governor's approval and gazetting, as well as the staff entitled to pension under relevant pension laws. From the documents tendered and admitted in evidence, particularly Exhibit OR1 to OR11, all the claimants were employed in 2016, except the fifth claimant who was employed in 2015. The second to fifth claimants were all confirmed in 2016. There is no document or averment relating to confirmation of the first claimant who was employed in 2016 as an assistant manager. See paragraphs 8, 9, and 10 of the statement of facts. The second and fourth claimants rose to the ranks of manager and assistant manager respectively. The other claimants were also heads of various units. Now, by Section 10.2 of the Kwara State Revenue Administration Law 2015, the provisions of the Kwara State Public Service Rules necessarily applies to the claimants until the board makes rules that are confirmed by the governor and gazetted. It is clear that the board made such rules in Exhibit OR44 titled Personnel Policies and Procedures Employee Handbook. However, the said handbook, Exhibit OR44, was not signed by anybody, and particularly there is no proof that it was approved by the governor and gazetted. The legal presumption is that the said handbook is yet to be approved by the governor, and so the employment of the claimants are still regulated by Kwara State Public Service Rules. From the above, no further semantics is required to come to the conclusion that the claimants are in the public service of Kwara State, governed by Kwara State Public Service Rules, and so their employment enjoys statutory flavor. I so hold. Whether the claimants' appointments were lawfully terminated. It is pertinent to note that the applicable rules, the public service rules of Kwara State, a confirmed public servant's employment cannot be terminated under the public service rules or any other rules by a month's notice or salary in lieu of notice. The provision of termination by 1 month notice or salary in lieu of notice in the claimant's letters of employment is only valid until their confirmation. As to the disciplinary procedure, the claimants contend that they were denied fair hearing. The first claimant says he was neither issued the said query, nor was he invited to attend the disciplinary panel. The contention of the defendants is that it was not in contention that the first claimant was not served with query letter and he did not appear before the disciplinary committee. However, there were evidence that he was informed about the query and invited to appear before the disciplinary committee and chose not to honor the invitation in Exhibit OR25. I put question mark because I did not see it there. However, by paragraphs 13 to 16 of the statement of defense, the first claimant was on leave and any contact between him and the defendants or the disciplinary committee was via phone call. That is from the defense itself. There is neither pleading nor evidence before this court that queries and disciplinary proceedings of the fourth defendant can be conducted by phone calls, let alone evidence of the said phone calls and their texts. It is therefore the finding of this court that the first claimant was neither served the said query nor invited to appear before any disciplinary committee and so was not granted fair hearing. It is the contention of the second to fifth claimants that we were invited to appear before the disciplinary committee on the 8th October 2017, less than 10 minutes after submission of response to the said query. The disciplinary committee collected copies of their report and asked them to leave without calling any evidence or cross-examining their accusers, and they were later served with the letter of service no longer required on the 23rd October 2016. The response of the defendants is a tacit admission thus. This is the response of the defendants. It was not compulsory for the disciplinary committee to call further evidence or confront the claimants with their accusers, as the allegations against them were proved by documentary evidence. This is a far cry from the requirement of fair hearing. Another interesting feature in the disciplinary procedure is that the claimants were not given enough time to defend themselves, contrary to Section 36 of the Constitution. The query letters were issued on 16 October 2017 on the allegation of inconsistency and unfair reporting of your staff performance, and the claimants were expected to submit their response before 4 p.m. on 17 October 2017. On the same 17th October, claimants were invited by Exhibit AK2 to attend the disciplinary committee on 18th October 2017. On the 19th October 2017, the board of the KWIRS sat and considered the performance of the claimants and resolved their services were no longer required on grounds of poor performance. This timing falls short of the requirement of adequate time to prepare for defense. On the whole, it is not necessary to go into a legal dialogue or exposition to find and hold that the claimants were not given fair hearing by the disciplinary committee. The claimants were denied fair hearing on all fronts, I so find and hold. Whether the claimants' appointments were terminated for the same reason for which they faced a disciplinary panel, and if not, whether the defendants can rely on a reason not stated in the termination letters as their defense. It is to be noted that although it is in evidence that the claimants, except first claimant, were queried and first disciplinary panel for inconsistency and unfair reporting of staff performance under them, the termination did not convey the said inconsistency and unfair reporting of staff performance under them as reason, contrary to the contention in paragraph 32 of the statement of defense. The reason stated in the letters of termination is poor performance, and this appears as the defense from paragraph 7 to 10 of the statement of defense. In exhibits OR 12 to OR 15, the query letters dated 16th October 2017, the accusations against the claimants read similarly as follows. Refer to your meeting with the executive chairman earlier today, 16 October 2017, and I underline the next statement. On the allegation of inconsistency and unfair reporting of your staff performance for July to September 2017, and your subsequent insistence on the accuracy of the said report. You are hereby requested to explain how you arrived at the breakdown of your staff performance and why the allegation of inconsistency and unfair assessment should not be held against you. Your response, which must be addressed to the executive chairman with a copy to the undersigned, must be submitted before 4 p.m. tomorrow, 17th October 2017, underlining mine for emphasis. However, the termination letters exhibits OR 20 to OR 24 all read similarly, except for the difference in their positions held in the KWIRS as follows. We write to communicate the resolution of the Board of Kwara State Internal Revenue Service at the 5th board sitting held on 19 October 2017 on your poor performance as a supervisor of the Directorate of Property Tax and Other Revenues. This is where it will differ in all the letters where their position is concerned. The board, after having carefully considered your performance as submitted by your head of directorate, hereby resolve that your service is no longer required on the grounds of poor performance. This takes effect from 3rd October 2017. That was even a backdated termination because we are already towards the end of October this later, and yet the termination takes effect on 3rd October 2017. You are by this letter required to hand over all properties and all relevant documents of the service in your custody to head Human Resource Department. The Accounts Department has been advised to pay you 1 month's salary in lieu of notice, underlining mine for emphasis. Little wonder the 5th claimant stated as follows under cross-examination. After my appearance before the committee, my appointment was terminated, but for a different reason. That was evidence of the 5th claimant. It is the finding of the court that the claimants were terminated for a reason other than that stated in their letters of query for which they faced disciplinary committee. Now, whether the defendants can rely on a reason not stated in the termination, that is, I have resolved whether their employment was terminated for the same reason in the query, isn't it? I've resolved that no, it was not the same reason for which in the query, which they stood disciplinary action for. That was not the reason. Now, the second leg of the question is whether the defendants can rely on a reason not stated in the termination letters as their defense. The place to look for the reason for termination of an employment is in the letter of termination and not the statement of defense. In the present case, it must be observed that inconsistency and unfair reporting of staff performance cited as a reason for the termination of claimant's employment is nothing but what the defendants think or suspect may have been behind the termination. In Uoha versus Mobile Producing Nigeria Unlimited 2011, LPLR 4477CA, the Court of Appeal held, in considering the issue of whether the termination of the appointment of the appellant was right or wrong, the court must confine itself to the letter terminating the appointment and not go outside it to look for other reasons which the appellant thinks or suspects may have been behind the termination. As in this case, of course, the defendant can think it was because of the wrong assessment, because they had just first disciplinary action and immediately they were dismissed. Well, you can just think so, but the letter is what must say, isn't it? That's what the authorities say anyway. So see also Elijah Taiwo, Banu, and 4 others was Executive Governor, Kwara State, and 2 others, suit number NICL/IL/16/2019, unreported, a judgment of this court delivered on 18th day of March 2021. This court has severally held that where no reason or where a particular reason is stated for the termination of an employee and he sues, the defendant cannot turn around to advance a reason or a different reason for the termination, even if that reason existed in fact. See Jimo Gabriel Yemi versus Executive Governor Kwara State and 2 others, suit number NICN/IL/11/2019, unreported, a judgment of this court delivered on 29th day of September 2022. Elijah Taiwo Bunu that I just cited above. Then see also Iwoha and Mobile Producing Nigeria Limited, Supra. There is no evidence that the claimants were at any time accused of poor performance as per their positions held, and they did not face disciplinary committee on the allegation of poor performance. The allegation for which the claimant's first disciplinary panel was not the reason stated for their termination of employment in the letters terminating their employment. The defendants are stopped from relying on the allegation of inconsistency and unfair reporting of staff performance as a reason for the termination at this point, as they are deemed to have condoned that fault, if any was found against the claimants. See Nigeria Army versus Brigadier Maude Aminu Kano, citation supplied, Lawrence Idemudia Abokale, forgive my pronunciation, versus Lasso, citation supplied, Chukudima versus Access Bank, citation supplied. The implication is that the claimant's employment were not terminated on grounds of allegation of inconsistency and unfair reporting of staff performance for which the first disciplinary committee, which allegation is deemed abandoned or condoned. The defendants cannot rely on an alleged offense which it condoned as justification for termination. See Ekonda versus University of Ibadan, citation supplied, Nigerian Army versus Brigadier General Maude Aminu Supra, Lawrence Idemudia Supra. Before leaving this point, as pertaining to the argument of the defendants' counsel that the employment of the claimants did not enjoy statutory protection, that will not justify termination for a non-existent reason. And I employ counsels to listen very well from here on this point. It is pertinent to note that the narrative of labor law jurisprudence has changed. The world has changed the world over, Nigeria inclusive. The common law position has been that an employer can terminate the employment of an employee for good reason, bad reason, or no reason at all. That has been the common law position. Even at the position of the common law, it was the position under common law that an employer is not bound to give any reason for termination, but where he gives a reason, he must justify that reason. NEPA or no NEPA will continue to work. Okay, I think it's NEPA that brought light instead. Even at that, it was the position under common law that an employer is not bound to give any reason for termination, but where he gives a reason, he must be able to justify it. Under the third alteration of the Nigerian Constitution 1999 as amended, by virtue of Section 154C, the National Industrial Court has jurisdiction to deal with unfair labor practices and international best practices in labor. The court is also empowered to apply international labor standards and international conventions to which Nigeria is a signatory, whether or not the convention has been domesticated in Nigeria. Section 154C1FH and 2 of the Constitution provide as follows, and I quote, notwithstanding the provisions of sections 251, 257, 272, and anything contained in the Constitution, and in addition to such other jurisdiction as may be conferred upon by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters, F, relating to or connected with unfair labor practice or international best practices in labor, employment, and industrial relation matters. H, relating to, connected, or pertaining to the application or interpretation of international labor standards. Then sub 2, notwithstanding anything to the contrary in this constitution, the National Industrial Court shall have the jurisdiction and power to deal with any matter connected with or pertaining to the application of any international convention, treaty, or protocol of which Nigeria has ratified relating to labor, employment, workplace, industrial relations, or matters connected therewith. In Sahara Energy Resources versus Oyebola, appeal number CA/L/109/1091/2016. The Court of Appeal in this judgment delivered 3rd December 2020 per Ogaku JCA describes the above provisions as an obligation on the National Industrial Court to apply good or international best practices. The court further held on the above provisions, including Section 7.6 of the National Industrial Court Act 2006 as follows. It is an innovative provision which seems to be directed at enthroning an entirely new employment and labor jurisprudence. Why I said you people should listen carefully so that you can look for the authorities and read and understand that when it comes to labor law or NIC, it's a new jurisprudence. It's not the old jurisprudence. If you stick to your old jurisprudence, you will be left behind. Now, the point I am trying to make here is that the termination of the claimant's employment for a non-existent or false reason will still amount to unfair labor practice under Section 15C1FH and 2 of the 1999 Constitution as amended. This is so because it is contrary to international best practice, Article 4 ILO Termination of Employment Convention 1982, number 158, for an employer to terminate the employment of its employee without any reason or justifiable reason that is connected with the performance of the employee's work. So it is no longer you wake up, you see that this man is threatening the position of your younger brother in the establishment. You say, this man, your employment is not, your services are no longer needed. That is no longer the position of the law. So, see Dr. Adekunle versus Kofna University, NICN ABJ 758-2016, a judgment of this court delivered by my Lord O.A. Obaseki Osage on 28 September 2021. In the above judgment, my Lord held, and I adopt them as mine as follows. Now, domestic law, international labor standards, and international best practice impose on the defendant a duty to establish the reason for the termination of claimant's employment to the satisfaction of the court. See NICER Council versus NICER Council. Okay, I think there's an omission here. NICER Council versus something is omitted. I'll look for it and put it there, sorry. But it is 1988, 1 NSCC 1025, 1988 3 Nigeria Report, Part 80, page 25. See also Petroleum and Natural Gas Association of Nigeria versus Klumbaja, Anadril, Nigeria Limited, 2008, 11, Nigeria Labor Law Report, Part 29, 164, and also Aloysius versus Diamond Bank PLC 2015, 58 LLR, that's Nigeria Labor Law Report. How could the reason of poor performance be justified given the facts of this case will require extraordinary imagination? there is admission by the defendants that the claimants met their work target, because the claimants said they set work target for them and then that they have met it. The defendants admitted it. But I put here in bracket, the legality of which practice has not arisen for my determination in this suit. Setting work target for staff, whether private or government, the legality of such practice has not arisen in this matter for me to determine or keep quiet over it. The claimants avert in paragraph 18 of the statement of facts as follows. The claimants avert that by September 30th, 2017, the target set by the erstwhile chairman of the fourth defendant had already been met and surpassed. The defendants responded in paragraph 10 of the statement of defense as follows. The defendants further aver that the fact that the work target set by the fourth defendant was met or not does not justify the misconduct of the claimants as queried by the fourth defendant. The allegation of poor performance, therefore, is one that was bound to fail. In essence, the allegation of inconsistency and unfair reporting of staff performance for which the claimants were not given fair hearing was abandoned. The reason of poor performance cited in the letter of termination, which has not been justified and is not justifiable on the facts of this case, amounts to unfair labor practice. Either way, the termination cannot stand. Resolution of the Kwara State House of Assembly. The claimants have pleaded that the Kwara State House of Assembly, upon claimants' petition, passed a resolution recommending the reinstatement of the claimants back to the services of the fourth defendant and then prayed in reliefs 3 and 6 as follows. I reproduce reliefs 3 and 6. 3. A declaration that the failure of defendants to give effect to the resolution passed by the House of Assembly to reinstate the claimants is unlawful, unfair, unconstitutional, unjustifiable, and against the principle of fair hearing and natural justice. 6. A mandatory order of this Honorable Court on compelling the defendants jointly and severally to give effect to the resolution of the Kwara State House of Assembly, recommending the reinstatement of the claimants back to the services of the fourth defendant without loss of revenue, benefit, and promotion. Whatever the resolution of the Kwara State House of Assembly on the dispute may be, it is not worth any price in court without establishing the cause of action and proving the claimant's case in court. It must also be noted that the resolution of the Kwara State House of Assembly is neither a contract between the parties herein nor a court judgment to be enforced by this court. The decision or resolution of the Kwara State House of Assembly is a legislative decision and does not fall under the decisions of an arbitral tribunal, commission, administrative body, or board of inquiry, which this court is empowered by Section 154C4 of the 1999 Constitution as amended to enforce. See Uzoma Gabriel Ume versus Honorable Minister of Health, Federal Republic of Nigeria, NICN/ABJ/111/2020 unreported. A judgment of this court delivered on 11th October 2021 by Anu J of the Abuja Judicial Division, where my law held. The jurisdiction of this court does not include or extend to enforcing resolution of the National Assembly, even if it related to labor matters. These prayers are accordingly refused for want of jurisdiction. Claimants' monetary claims. The monetary claims of the claimants are contained in paragraphs 85 to 91 of the statement of facts, as well in the various witness statements. The response of the defendants to this is in paragraph 61 and 62 of the statement of defense, which states as follows. Paragraph 61. The defendants, in response to paragraphs 85, 86, 88, 89, and 91 of the statement of facts, aver that all the claimants are by law not entitled to any salaries or sums of money mentioned in those paragraphs because their respective appointments have been duly and validly terminated. 62, the defendants, in response to paragraphs 87 and 90 of the statement of facts, aver that in the same vein expressed in the preceding paragraph of this defense, the second and fourth claimants are not entitled to any sum of money mentioned in those paragraphs as their purported responsibilities allowance. The second and fourth claimants are put to the strictest proof of same. Now, the reason for the denial of the claimant's entitlements from these paragraphs are simply because their respective appointments have been duly and validly terminated. The existence of such salary arrears at the stated rates or allowances at the stated rates are not denied. The claimants are accordingly entitled to the said monetary claims since their case have succeeded. The claims for general damages must fail as it will amount to double compensation, where the claims for special damages in terms of salaries have already succeeded. On the whole, the claimants have proven their case on the merits and their case succeeds. The reliefs claimed by the claimants succeed and are hereby granted as below. For the avoidance of doubt, it is hereby declared and ordered as follows. This is where we will take the long journey that we avoided before. 1. A declaration that the purported queries, disengagement, and the subsequent confirmation of dismissals of the claimants from the employment of Kwara State Internal Revenue Service, KWIRS, by the defendants in their letter dated 15 September 2020 is unlawful, malicious, unjustifiable, unconstitutional, and against the principle of natural justice and fair hearing, null and void, and of no effect whatsoever. 2. A declaration that the claimant's employment with the fourth defendant, Kwara State Internal Revenue Service, is still valid and subsisting. 3. An order reinstating the claimants to their erstwhile positions in the Kwara State Internal Revenue Service. 4. A declaration that the claimants are entitled to their salaries, employment benefits, emoluments, and perquisites of office from November 2017 to the date of this judgment and thereafter till retirement. 5. An order compelling the defendants jointly and severally to pay each of the first, third, fourth, and fifth claimants the sum of 7,222,845 naira only, being their salaries from the month of November 2017 to September 2020 at the rate of 206,367 naira only per month. 6. An order compelling the defendants jointly and severally to pay each of the first, third, fourth, and fifth claimants the sum of 2,476,404 naira at the rate of 206,367 naira only per month, being their monthly salaries for 12 months from October 2020 till date of judgment today, 3rd November 2021. 7. An order compelling the defendants jointly and severally to pay the second claimant the sum of 8,873,907 naira, 970 naira, being his salary arrears from the months of November 2017 to September 2020 at the rate of 253,542 naira only per month. An order compelling the defendants jointly and several to pay the second claimant the sum of 3,442,504 naira at the rate of 253,542 naira only per month, being his monthly salaries for 12 months from October 2020 till date of judgment today, 3rd November 2021. 9. An order compelling the defendants jointly and severally to pay the second claimant the sum of 2,100,000 naira, being his arrears for responsibilities allowance as a manager from the month of November 2017 to September 2020 at the rate of 60,000 naira only per month. 10. An order compelling the defendants jointly and severally to pay the second claimant the sum of 720,000 naira at the rate of 60,000 naira only per month, being his monthly responsibility allowance as a manager for 12 months from October 2020 till date of judgment to date 3rd November 2021. A mandatory order compelling the defendants jointly and several to pay fourth claimant the sum of 1,400,000 naira. It's 2 million. 2 million. Isn't it? Not 1 million. 2,400,000 naira only, being his arrears of responsibilities allowance as a manager from the month of November 2017 to September 2020 at the rate of 40,000 naira only per month. A mandatory order of the Honorable Court compelling the defendants jointly and severally to pay the fourth claimant the sum of 480,000 naira at the rate of 40,000 naira only per month, being his monthly responsibilities allowance as a manager for 12 months from October 2020 to date of judgment to the 3rd November 2021. The judgment sum is to be paid within 30 days of this judgment, or it shall attract 10% interest per annum until same is finally liquidated. This is the judgment of the court, and it is entered accordingly. Thank you, gentlemen, for your patience. This is Saliman.
Yes, my lord. I describe this judgment as a life-saving, life-changing, and a cause of justice at its best.
Bello.
We are grateful.
Beloved sir. Beloved sir. We are grateful for the well-considered judgment, sir.
Thank you.
And I pray God to continue to enrich your lordship in knowledge and wisdom, sir.
Thank you. Thank you, gentlemen, and that is all for the judgments. And I too will leave the meeting.
Thank you,
so
sir.
You are free to leave as well.
Thank you, sir. We are most grateful.
Thank you.